Judgment in the appeals in the matter of Evie, a child.
Lord Reid will give the judgment to the court.
These appeals arise out of an application by West Lothian Council for a permanence order under the Adoption and Children Scotland Act 2007. That is to say, an order granting the local authority parental responsibilities and rights in relation to a child, including authority for the child to be adopted. The child was born on the 30th of December 2013 and has been in care since her birth. The application is opposed by her parents, both of whom have experienced learning difficulties throughout their lives. Section 84 of the 2007 Act sets out the conditions and considerations applicable to the making of a permanence order. These appeals are particularly concerned with Section 84(5)(c)(2), which imposes a threshold test. Before making a permanence order, the court must be satisfied, in relation to each of the parents, that the child's residence with that person is likely to be seriously detrimental to her welfare. In this case, the local authority's concerns mainly relate to the child's father and arise out of allegations concerning his behaviour before she was born. The Lord Ordinary, after hearing 9 days of evidence, granted the permanence order with authority for adoption. He made few findings of fact in relation to the issues in dispute, and none in relation to the question whether the threshold test was satisfied. Instead of considering whether the allegations were relevant to the threshold test, if so, whether they were true, and if so, whether the test was met, his approach was to consider whether the local authority's actions had a reasonable basis. His decision was upheld by the Inner House, except in relation to the grant of authority for adoption and a related prohibition on contact by the parents. The parents now appeal to the Supreme Court. The Supreme Court unanimously allows the appeals and refuses the petition for a permanence order for reasons set out in a judgment prepared by myself with which the other members of the court agree. The court holds that the threshold test has to be met before the court reaches the stage of considering whether to make a permanence order under the other provisions of Section 84. The judge is the primary decision maker in determining whether the threshold test has been met and must base his or her determination of that issue on findings of fact. The judge is not exercising a merely supervisory jurisdiction over the approach taken by the local authority. That conclusion is consistent with the conclusion this court reached in earlier cases concerned with the threshold test imposed by the corresponding legislation for England and Wales, most recently in the case of In Re J in 2013. The legislation needs to be construed in a way which strikes a proper balance between the need to safeguard children and the need to respect family life. The requirement that residence with the parent is likely to be seriously detrimental to the child's welfare indicates that depriving parents of their parental rights and responsibilities is a serious matter and should only be done if strict criteria are satisfied. The requirement that the court must be satisfied indicates that suspicions cannot form the basis of the order and can be contrasted with the statutory language used in other situations where suspicion may be enough. This court also holds that if a court finds that the threshold test is satisfied, it must make clear, first of all, what the nature of the detriment is, which the court is satisfied is likely if the child resides with the parent. Secondly, why the court is satisfied that it's likely, and thirdly, why the court is satisfied that it is serious. So in the present case, the alleged behaviour about which the local authority was concerned could only be relied on as the basis of a finding that the threshold test was satisfied if the allegations were relevant to that issue, if they were proved on a balance of probabilities to be true, and if they satisfied the court that the child's residence with her parents was likely to be seriously detrimental to her welfare. The Lord Ordinary did not approach the case in that way. He did not determine the threshold issue, but instead considered whether the local authority's concerns about the child's father had a basis in evidence. The correct approach would have been to consider whether the allegations were relevant to the threshold issue. If they were, then the Lord Ordinary should have made a finding of fact on a balance of probabilities as to whether the allegations were true. If he was unable to make such a finding, he should not then take the allegations into account in his consideration of the threshold test. The application for a permanence order will therefore be refused. It remains open to the local authority to commence fresh proceedings as and when that may be appropriate.